Please welcome our next speaker, Liubov Voitsekhovska. Liubov is a partner at TAXUS R&F Ltd. She will tell everything about legal aspects of using images of real people and historical figures in computer games. I am giving you the stage, Liubov.
Hello all. I'm glad to welcome you today at this lecture. First of all, I wanted to say that I'm really grateful to Games Gathering. This is not like the first time that I speak for Games Gathering audience, and this time I will try to do my best also to highlight some interesting topics from legal aspect of games for you. I suppose that this lecture will help you to avoid some pitfalls maybe in your activity and to check some of your ideas that you might have in future. Thank you for joining. Wishing you a very pleasant hour with me, and let's start. Okay, so our topic to discuss today is legal aspects of using images of real people and historical figures in computer games. Why is this question actually so interesting and burning? And these are some main contents that we will cover. Some peculiarities of the use of images of real people and famous personalities. Also, the right to publicity, and what's that? Maybe somebody will hear this definition the first time in their life. Maybe somebody heard before. But anyway, this is something to consider before trying to implement real images of real people in your games. Also, we will discuss which aspects are protected by this right, some tips from legal regulation from the US and other countries, and also my recommendations for game developers and artists, what to think about before implementing some real images of real people into your games or even works of art. Okay, so let's proceed. Use of the images of real people and famous personalities in the games. I'm sure that you might from time to time be interested in getting some famous person to your game or to your advertising materials of the game, but you might have the questions similar to those which are specified here. For example, may you use the image of a real person in my game? Should I ask for some consent, or should I pay money to this person? Also, what if it's a famous politician or a famous sportsman, or maybe it's a singer or an actor, some personality which already has reputation, which already has image, and can this image really make some commercial profit for you and for this person? Is it okay to use the image of the personality which is dead? For example, there are a lot of famous people, famous politicians or actors and so on, which are already dead, which are no longer with us. But anyway, the users may be still interested in this person images being engaged in your game. Also, should I ask this person's heirs? For example, if the person is dead, then there is like a logical question: is this right for publicity inherited in any countries or in any way? Also, the question might be, may I use a portrait or a historical photo of the person? Not always. You may take a real sketch from a real person, which is made by your own developer, game artist, for example. Sometimes you have to use some photo which was made by somebody. So in this case, the situation may also be tricky. I'm sure that you might have some other additional questions also, but let's start with this one. Okay, as regards using of real people in the games, here are some cases that come to my mind, and some genres of the games where using of a real person may give a lot of peculiarities and a lot of profit to you as a game designer, and may attract a good audience for you, especially people that are keen on history, for example, or on sport. And these are like the most popular genres when you can see the use of the personalities in the world. For example, we may take the war games. They may be based on the some historical personalities of like the Second World War, or as you can see, one of the examples like the famous Hearts of Iron series, for example, or also they used, for example, the portraits of famous politicians at those time and famous commanders at those time, and this may also have some additional regulation. Also, some case that comes to my mind is the case when it was a lawsuit by Manuel Noriega, the ruler of Panama at that time. He brought a claim against Activision for the game Call of Duty Black Ops 2, where one of the main anti-heroes was looking really like this Manuel Noriega, and he really wanted for the company to pay him some money. Also, you can see the reference on my screen for Adolf Hitler in shooter video game Sniper Elite third part, and I'm sure that in many other war games you can see real people from the ancient times and so on. If we talk about strategies, the situation is almost the same. You may even see some ancient personalities like Julius Caesar or Cleopatra, or maybe Genghis Khan, or other famous warriors and other famous rulers in different strategies and so on. If we talk about sports simulators, this is also a very popular genre where, for example, you can find some precedents with low cases from famous sportsmen. For example, if we talk about FIFA, there was a case when EA used some images of real footballer players, and they announced their desire to be paid for these and to be protected. Also, one of the examples is the use of the name of famous baseball player Tiger Woods in the same name Tiger Woods PGA series, which is also a computer game, which was rather popular between the fans of this baseball player. So you may also remember about the images, for example, of Keanu Reeves in Cyberpunk 2077, or, for example, the use of the voices of real actors in The Last of Us series, and all of these use of real people and real regulations and real person, they should be regulated. Also, if we are talking about, for example, some people that are already dead, one of the examples is, for example, the license that Marvel got for using a Stan Lee image in its series of films and comics and so on. And this is also the right and the license for this, which was agreed and paid for. So this is actually a very, very important thing to consider before starting your project, if you are planning to use the real images of real people in the games. Okay, so what was all this about? What were all these real cases about? I wanted to present to you such definition as right to publicity, and to tell you what's that. Of course, for us, for legal people, it can be like something obvious that if a person has some reputation, or a person has some image which can be used for getting some profit and so on, this person might have the right to protect this. So to say like in a bit of legal language, right to publicity is a special kind of intellectual property right which protects the image and attribute of a certain person, an actor, a singer, a TV presenter, a famous scientist, for example, against illegal commercial use by third parties. The accent is really made on the commercial use, for example, because if we are talking about other types of use, they might be, for example, for some social purposes, for some political purposes, for some news, and so on. And in this case, this right to publicity doesn't work such strictly as in the case of your commercial use of the images of some people. So let's provide more details. Why is the right to publicity such a special thing? Why is it different from other intellectual property rights? I'm sure that you already know from your practice about the existence of some intellectual property rights, for example, for drawings, for software code, for music, and so on and so forth. And it's like a natural from day-to-day thing for you as game developers, as the artists, and so on. But what's specific as regards the right to publicity? The thing is that those rights that I told you and discussed you previously are rather well known and very good recognized in different countries, in different laws, and also in international conventions and in international laws. But if we talk about right to publicity, it differs significantly from other intellectual property rights because it has no clear definition and consolidation in international documents, and also the legislation of many countries has very different approach to this right, and that's why this is a bit more shady question when we need to consider a lot of aspects before looking at this or that country, at this or that right to publicity. Okay, so let's go further. Also, although there are some differences in the legal protection of this issue, there are three main criteria in all jurisdictions for a celebrity's claim to have their image protected. For example, the first criteria, the defendant used the image of the celebrity, maybe some visual image or a name, as a value associated with the celebrity, and such use was not carried out accidentally or for informational purposes. This is the case that I told you about. If you're using something for commercial reasons and you knew that you're going to use this image of this famous person in order to get some profit, to attract some audience to your game, then you fulfill this first criteria. The second criteria is that the celebrity can be identified based on the content of the defendant in which his or her image is presented. This is a very tricky moment also, because if you're just taking a photo of the celebrity and each fan can easily guess who this person is, then it's rather clear. But what if, for example, you use only some part of the image, or you use only some specific gesture of the person, or maybe some specific characteristic which tells the fans about this person, but not so clearly. In this case, we'll have to see whether for everybody it's quite understandable about which person this story goes, and whether it's such a clear scene, or maybe that's just a parody or some additional image of personality that you created for your game. So this moment is rather tricky. The third criterion is the defendant received commercial benefit from such use of the image of a celebrity. I suppose that this is also might be obvious. For example, if you used the face, I don't know, of some Hollywood star, Keanu Reeves or Selena Gomez, a singer, and somebody else face for your game to promote it, you used it like in your marketing materials, you used it in your most interesting scenes of the game, and you got some benefit, some commercial benefit from it, then it's obvious that you fulfill the third criteria. But in some cases, it's not so easy to say whether the reason of using this personality was leading to getting some commercial benefit from your side, and this criteria also is important to prove. Okay, so let's continue. If we talk about the right of publicity, we can split this right into several aspects which may be protected by this right. Not all of them may be protected in all of the jurisdictions, in all of the countries, but these are the main ones which you should consider before starting some project. For example, the name can be protected. It can include the name, the nickname of the person, the stage name of the person, or anything which is sufficient to identify this particular celebrity, this particular person. Because in some cases, this can be like a nickname which was used in some of the films or in some of the social networks, for example, or really some stage name. Another thing which is protected is the image. It can include any part of a person that is sufficient for that person to identify him or herself. This may be like some specific mustache, for example. This may be some specific glasses or even dresses and so on, some specific haircut or something that really differs this person from others and makes it easy for the fans to recognize the person. Also, the portrait can be specified as such an aspect. It can include a cartoon or illustration, which even may be another object of intellectual property rights. That's another tricky moment to consider that we should think about, because when somebody makes a photo, he is also the author of this photo. When somebody makes illustration, cartoon, portrait, parody, or something like this, you not just depict the famous personality, you also create another object of intellectual property right. And in this case, if you want to use the portrait or a cartoon or illustration, you should also always consider the agreement with the actual author of this object of intellectual property right, and not only the agreement with this famous personality. Another thing which should be protected is a similarity. It can include a look-like or a real person who looks like a famous person through makeup, for example, or even an inanimate object, such as a robot, that looks like a celebrity in appearance or in some event contexts. To illustrate to you more properly this case, I would like to tell you about the real situation, which was which happened during the advertisement of Samsung Electronics America, and in one of the advertisements they wanted to show some future of humanity, where some robot which looked very similar to famous TV show star, he turned he turned the lottery, and he chose the winners. And in this case, those TV show star, she made a lawsuit to Samsung for this advertisement, because those that robot, also not being like a real human, just being an animated object, but was very, very similar to her from the point of view of appearance and the point of view of all the interior around, which looked really similar to those TV shows. And she really got some compensation for this, because the court said that yes, really, she has the right for this personality, for this similarity. Another thing, another aspect which may be protected is signature. Signature may be considered both literally and figuratively. For example, literally, it can be an autograph or handwriting of a famous celebrity. If you use it, for example, to say that this celebrity gave her handwritten autograph to say that this game or this product is the choice of this celebrity, or if you say that this celebrity, for example, visited your office and left her or his autograph, and in this case you want to attract more people to your company, attract more people to your game, then this can be considered also as the aspect for protection for this celebrity. Also, the signature may be considered as figuratively, because, for example, it can be some signature in social networks or some catchphrases of this celebrity. For example, if you wanted to show in your marketing material that Kim Kardashian liked the game or something like this, then using her photo and using her name from Instagram, but for example, correcting couple letters, still, if you can guess this actor in this famous person in this signature, this can be protected. Also, we're talking about, if we're talking about options for protection, this may be gestures. They can include some specific gestures, moves, mimics of the famous people, which may be associated only with this personality. I'm sure that you might remember some examples of famous gestures which are shown in videos or in some old films and so on. So please, before using anything very, very specific and recognizable, think about protection of right for the gesture of this person. Personality. This might mean the complex features which point to the identity of the celebrity. Even some elements, some vaguely resemble the image of celebrity, can be perceived by the court as infringing the image of this famous person. Actually, if we're talking about personality, one of the most developed and strict legislation in this case is made, of course, in California, where a lot of celebrities wanted to use their rights for protection of their name, of their image, and also of their personality, because personality is a very, very complex thing which may combine together the name, the portrait, the image, or some gestures, and so on. So in this case, the court will be very precise and will try to look at very different sides and aspects of this case. And also, of course, the voice. If some voice is really good known by many people, and you want to use the imitation of this voice in your games, then you should consider also the protection of the voice. Okay, just a second and we'll continue. If we talk about the legal regulation of the right to publicity, why I decided to start from the USA? Because, as I said before, the USA is one of the countries where the right to publicity is the most complex and the most progressive, so to say, if we talk about a lot of new and interesting cases. As I already told you about California, for example, but even in the USA, it is not fixed at the federal level in the USA. Each state sets its own laws on this matter. In some states, the courts protect only the image and names of celebrities. In others, the voice or even the signature of a famous person may be protected. So the situation is that you should always look case by case. Some of the examples for you just to have the understanding. For example, Lanham Act prescribes a civil liability for confusion or mistake which connected with some person that leads to understanding that this person approves some of your product or provides its sponsorship to the product, to your goods and services. And this provides you some better conditions for advertisement of your product comparing to the others, to your competitors. And if the reason is using the name of this person, the reputation of this person, then it is regulated. For example, in New York, you may see the provisions that you may not use the image of a real person without the written consent of such person. Or if we are talking about a minor, then without his or her parents or guardian consent. And if you do so, then this is also the breach of the law. If we talk about California, it went much further. California has even California's Dead Celebrities Bill, which protects the rights of the heirs of deceased movie stars, musicians, athletes, and other famous personalities to commercial use of their images. So California protects not only living people, which are famous right now. California protects also their rights after their death for future, and provides to their heirs the right to give a claim to start some lawsuit against somebody that break the right to publicity of their ancestors. Also some examples from Indiana, Oklahoma, and Tennessee, which also protect the rights for publicity for dead personalities, even, for example, 100 years after the death. Let's go further. For the USA, these are like the most interesting examples, but of course, we should consider each state separately. This is just a brief overview for you for the other parts of the world in order to see how different the countries may have attitude to right to publicity and actually to the regulation of this in many countries. I should say that in the modern world there are several legal systems that maybe you heard about. These are the systems of common law, for example, which are the UK, the US, Australia, and so on. And they are mainly based on precedents. So this means that if the courts have some practice for these matters, then this aspect of life will be regulated. The other system is it's called continental system, which mainly deals with some specific laws and regulations first being adopted by the government of the country and only then being used in practice by ordinary people, and all the courts, they make decisions according to the laws and not according to the previous practice. So here we may see the examples of regulation of law right to publicity by different countries of different legal systems. It's interesting that, for example, in the UK, there is no separate protection of a personality of a person's personality. There was a very interesting case if we talk about Elvis Presley when he wanted his image and his name to be protected. And the UK court said that you don't own the name or you don't own your face, for example, and you cannot just decline and for any person to make a tattoo with your face or to draw this face on a car or something like this. And in this case, the UK declined in the protection of this person's personality. But in many cases, the legal protection of right to publicity really is enforceable in the UK if we talk about some officials and protection of the image of famous person, which is connected not only with his or her name and image, but also with commercial realization of this reputation of this personal of this famous person. If we talk about Cyprus, for example, people that are depicted in some photographs, they really can oppose the use of these photos in advertisements and publication in magazines and so on, which tells us that if you're going to use some photo of a real person from Cyprus in your game, you should also ask for some consent or for some to provide some remuneration to this person in order this could be legal. If we talk about Jamaica, for example, this was also a very interesting case when the Supreme Court of Jamaica acknowledged a property right of a personality of Bob Marley, which survived after his death. For example, I'll tell you a bit about other continental countries. In most European countries, for example, you might find some pieces, some parts of also the right to publicity. In different countries, they may be limited. Some countries, it's hard to say that they are regulating exactly the right to publicity, but they may regulate only some aspects. For example, if we talk about Ukraine, as I'm currently in Ukraine, I will tell you that, for example, in Ukrainian legal system, you may find the law of advertising, which states that it is prohibited to include an image of an individual in an advertisement or to use its name without the written consent of that person. And unfortunately, that's all. The image of the person is not regulated as an intellectual property object, unfortunately. But, for example, if you say that you're a famous person, and if you say that your image was the result of your creative thinking, was the result of your some creative actions and so on, and it's really like the work of art, for example, that you created by yourself, your maybe your costume or something like this, then it can be really protected by Ukrainian law as an intellectual property right for this object of art, for this image that you created for yourself, but unfortunately not for your face, not for your personality. In other countries, also different regulations might be implemented. So I highly insist for you to check before using this or that images of real people. Okay, so here are some recommendations for you. I'm sure that this presentation will be shared with you, but and these tips will be really, really useful, but I will try to tell you something more with my comments, and maybe you will remember like much better than just reading the presentation. Okay, so what I would recommend you, not to use any images of celebrities in your marketing advertisement materials, game covers and game icons, or on your screenshots or other elements of the game. If you have no agreement with this person and if you have no consent for this. Because this actually may lead you and your team and your company to the lawsuits with huge fines, and that's why it's better to avoid it. It's not recommended to use the images of celebrities in the content of the game itself, or otherwise you can change the character's name, for example, or adjust its appearance to create only some indirect association with the famous person and not to depict a person directly as it is. If you, of course, you don't have some agreement with this person. Also, if it happens so that you're using some images of celebrities in your game's marketing campaign should not emphasize the fact that it contains the images of famous personalities, because this is actually one of those criteria that we were talking before in the very beginning of the lecture, that if you get the commercial benefit only because you used some famous celebrity in your game, then there is a case when you fulfill one of those criteria. And also, it is safest to use in the game the images of people who have already died by the time the game is developed. Of course, you should always remember that some of the states recognize the right for protection of this right for publicity for the heirs of this dead personality, but a lot of states and a lot of countries don't, and that's why it's better to make some small research before using the image. But anyway, you may also use the images of some people which you, for example, know for sure that 100 years, for example, already passed since their deaths, and you can use them freely. For example, if we talk about like civilization game, where the images of Cleopatra, of Julius Caesar, and other famous people of the very, very ancient times, they are used freely without any claims for the possible heirs of these people in the reality. Okay, the following recommendations are: If you really want to use the image of a famous person in your games, it is better to get his or her written consent for this, or also to conclude an appropriate contract. This also is actually up-to-date situation not only for the famous person, for any real person that you want to use in your game. It's much better to have the consent of this person before making some sketches or photos or even live models of this person. It's better to have its written consent or even to have an appropriate contract. Sometimes you can even agree for some remuneration with this person and so on. And in this case, this person will transfer its consent to you, will provide you the license, so to say, to use her image, his or her image, and this aspect will be legal. You may feel free and not to be afraid of any lawsuits in future. Also, I highly recommend you to make sure that you have contracts, consents, and licenses for the use of all objects of intellectual property and their components. This is the case when you not only use the image and the name of the person, you might also use some music, some photos, some sketches, and some videos, and so on. All these objects, all these components are the intellectual property right objects, and it's better for you always to check whether you have a right or maybe a license from the author of these objects to use them in your game. Also, I highly recommend you to make sure that all the individuals that you portray are of legal age, because otherwise you have to obtain the consent from the child's parents for portrayal, and the consequences of not doing this may be rather serious and may impact you in further lawsuits. For example, if a person is not famous, but you still want to use his or her image in your game, also consider their rights for publicity, because you know life is really changeable, and maybe one day this person becomes really, really famous and may even tell you that I no longer want that you used my image in your game. So not only celebrities have the right for publicity, but also ordinary people. Please keep it in mind. Well, now I want to thank you for your attention, because I see that the time is really coming, and I want to share with you some contacts, maybe some QR code that you may use to contact me further.
Liubov, thanks a lot for the presentation. It was very interesting to know all of those things. And I believe we can move to the questions now, if you don't mind. So the first question would be, if a celebrity or another person is from the USA, but the company that used her personality is from Europe, for example, what law institution will be applied for this case?
Actually, this celebrity always has the right to make a lawsuit in the court where he or she is actually situated. So this claim may go to the US court, and the celebrity may claim for protection in that state where he or she is situated. And international court procedures, they are also possible, and I should say from practice that for example, for the European company or for the Asian company, it's not really easy to be the part of the procedure in the US courts, so please consider these aspects before doing so.
Okay, thanks a lot. The next question would be this one. There was a well-known case when actress Lindsay Lohan claimed that her character was used for one of the NPCs in Grand Theft Auto 5. And the court actually rejected her contention, as she claimed that it was just an inspiration, so the character was inspired by her. And what do you think about this? Because before you have told us about the case when the actor's right was on against was approved, and in this case it was declined.
Actually, it always depends, because many cases, many lawsuits where we are talking about intellectual property objects, they may be tricky, and they highly depend on the thoughts that the judge has as regard this case, and it's not always like the same in different situations. What you have to consider anyway is if this character very, very, very similar to this actress or to this famous personality. And this is the question that the court has to decide. Another question is to decide is whether the use of this exact character and this exact personality brought commercial benefit to you. And if it did not, then maybe there is no even reason to claim some money from you, because you did not gain this commercial benefit from the use of this image. It is always case by case, and also, as I told you before, if we talk about the US courts, in different states, they regulate and treat this right to publicity in different ways. In some states, they protect only the name, for example, just saying like Lindsay Lohan, and that's all. And in other states, they can protect even the gesture of Lindsay Lohan. And that's why you always have to see, to look individually at each case and at each image.
Okay, thanks. I believe that's all for now. If you have any other questions, I believe you can write Liubov in private messages
Sure.
or something like that. Yeah, thanks. I wish to see you again on Games Gathering. Thanks a lot, and everybody for being today with us. Bye-bye.
Thanks a lot. Bye-bye.